Hi, my name is Noel Doherty. I'm a partner in FitzGerald Solicitors in Laoi in Cork. We have a thriving general practice, but I work mainly in the areas of family law and child law. I act for private clients in family law cases in the District Circuit and High Court, and I have a particular interest in family law cases involving children. I also act for the HSE in public law cases. I suppose I want to say firstly that the views expressed here are my views, my personal views, not the views of my partner, my firm, or any of my clients. Covering the back. I suppose at the moment in family law and in childcare, most of the work is done in the court system. And while I am a passionate advocate for alternative dispute resolution, and that's what I'm talking about tonight, I think it's very important that the court has a role. And I think when family law cases come before the court, it's imperative that the court deals with them in a respectful manner and deals with clients in a respectful manner. And it's not feasible for the court when parties come before it to say, go outside and settle. That's not alternative dispute resolution. That's simply refusing to deal with the issues, refusing to respect the clients, and passing the buck. And I think that needs to stop. Currently in Cork District Court, you'll wait 5 months to get a hearing date. So if somebody comes in to me to look for access to their child or to look for maintenance, I will tell them that towards the end of July, start of August is when your case will come up. 5 months is a very long period of time for a child and for a parent not to have access, or for a person not to have support for their child. I've often stood outside the court, the district court in particular, for a full day waiting for a case to come on. Recently I was outside a court, there were 60 cases in the list. My case was adjourned at 5 p.m. There were 80 to 100 people standing on the street in a public place. No facilities. It did, of course, start to rain. And a thought came into my head. Why don't we get a tent? A big marquee. And portion it off on the inside, make rooms of it, and hire a couple of mediators and talk to the lawyers and bring people in. They have their legal advice with them, provide them with mediation, and a significant number of those cases would settle, as opposed to standing outside in public with no facilities. You could even provide some heaters. It'd be wonderful. I think it's the Dolphin House project is probably a realisation of my white tent theory, but I think it needs to be thought about more. It seems to me that there must be a better way to provide a family law service and to provide for the needs of children in family law disputes. A highly experienced and proficient and prominent family lawyer made the following statement: "The reality is that we have a chaotic and dysfunctional family law system, and those who embark on matrimonial litigation seeking a decree of judicial separation or divorce are travelling a perilous road of uncertain destination." That statement was made by our Minister for Justice, Alan Shatter, in 2006. I have another quote from the Law Reform Commission's report on the family courts. This report issued in 1996, 16 years ago. "Structures which this society offers for the mediation and resolution of family conflict are inadequate in the extreme. The courts are buckling under the pressure of business. Long family law lists, delays, brief hearings, inadequate facilities, over hasty settlements are too often the order of the day. At the same time, too many cases are coming before the courts which are unripe for hearing, or in which earlier non-legal intervention might have led to agreement and the avoidance of courtroom conflict. Judges dealing with family conflicts do not always have the necessary experience or aptitude. There is no proper system of case management. Cases are heard behind closed doors, protecting family privacy but offering little opportunity for external appreciation, criticism, or even realisation of what is happening within the system. The courts lack adequate support services, in particular independent diagnostic service, so important in resolving child-related cases. The burden placed on those who operate the system, especially the judges and court officials, has become intolerable. That's the Law Reform Commission report on the state of our family courts in 1996. So, who are the gatekeepers of this process? The lawyers are the gatekeepers. Most people here are lawyers. We're the people who take the clients in with the problems and we direct them as to where to go. Why are we directing them into a court system which produces results like it produces? I was appalled recently that the training course for trainee solicitors used to have an ADR element in it, but that has been removed. So all of the solicitors that are coming out of the training system at the moment don't get any exposure whatsoever to any ADR issues. Of course, the courts are necessary in family law. There will be cases that will inevitably lead to court hearings, and those hearings are necessary and they should be respectful. But I would suggest there has to be a better way. Some research on Billings and Emery did a longitudinal research on the results of family law cases that were allocated by the flip of a coin. So heads you went to litigation, tails you went to mediation. Quite brief mediation, 5 or 10 hours at max. And they found that 20% of cases that went to mediation appeared before a judge, 75% of litigation cases went before a judge. After 12 years, they revisited those people. And 28% of non-residential parents met their children on a weekly basis if it came through the mediation system. 9% if they went through the litigation system. 52% of the mediated cases, the non-residential parents spoke to their children once a week by telephone. 14% of those who went through the adversarial system. I'm a trained mediator. The skills I picked up in mediation were probably the best skill set I've ever picked up. I'm one of the founding members of the Irish Collaborative Practitioners, the ACP, and I suppose being a collaborative practitioner made me proud to be a lawyer. I could again say that I was trying to help people to find solutions, working in an interdisciplinary team, helping people to find long-lasting, real solutions over which they had control, not the court, not a rushed settlement. ADR, mediation and collaboration, and the other forms of ADR give the clients more control over the outcome, more control over the costs, greater confidentiality. They reach deeper, more sustainable solutions with less hurt, and the outcomes generally benefit the children because there's less conflict between the parents. The draft bill has been launched in relation to mediation. I'd have some comments for the Minister in relation to it. I think the definition of mediation needs to be extended. It needs to refer to alternative dispute resolution methods, including collaborative practice, co-mediation and others. In Head 7, I think the Minister needs to withdraw that section, that's one of the subsections there, which suggests that any party to a mediation can request a third party to come in and accompany them, or third parties to come in and accompany them. I don't see how that can work in a mediation situation where if I'm in mediation I can have 3 or 4 people to sit by my side, all of which may be destructive to the process. I believe that it's very positive that cases can be suspended and the parties can be asked to attend an information session on mediation, and that costs can be awarded against them if they unreasonably refuse to do so. So all of those alternative dispute resolution methods will be enhanced if the bill is expanded to some extent, and I think that will benefit children. With regard to public childcare cases, I believe that there is significant potential for the enhanced use of family welfare conferencing, and I'd agree with Colm in relation to that. if a case comes before the court, if a case comes to the point where children have to be taken into care, it is a failure to a significant extent. However, it does happen. I would suggest that in childcare cases there's a perceived imbalance where the state and the apparatus of the state is imposing its will on a parent in relation to their relationship with their child. I am suggesting that a role of an advocate or a process support worker would be helpful in that regard, whereby this person would not be a lawyer, would not act as a lawyer, but would assist the parents to be able to deal with the processes involved, the meetings, etc., and be a support to the parents and support the parent in dealing with their solicitor. I think that the Minister should introduce much more clear and significant rules around case management. There's quite an interesting document, the Guide to Case Management in Public Law Proceedings in Northern Ireland, and I can give you a reference for that if you wish, whereby it sets out a process, a very clear process, and provides space for negotiation to take place, space for documents to be exchanged, and it's a stepped process before the matter comes to trial. I think that's very important. I think that it would be ideal if a safe container could be created for the parties involved in childcare so that they can talk in a without prejudice process and clarify all the issues that need to be clarified prior to going to court. I think that could reduce the characteristic cross-examination that can occur because the issues are so fundamental to the parties. I'd like to thank you all for your kind attention. I hope you all agree with me that a change in the current system is absolutely vital because it doesn't serve our clients, it doesn't serve the children of our clients, and it's imperative that it does so. I'd hope that the Minister will also agree that a change is imperative. I'd request the Minister to extend the definition of mediation in the Act, make the other change with regard to not allowing parties to bring others in willy-nilly into a mediation, and introduce a comprehensive, clear, transparent case management system in public law cases where parents would have the right to have much more clear idea as to what's going on, and equally that there would be an ability for social workers who have the interests of the children at heart to be able to communicate those interests effectively in a secure way, leading to solutions which I think will be less adversarial, solutions where social workers and parents will be able to work together for the benefit of the children on an ongoing basis. Thank you.